The government is on the hook for violating its own labor laws. The federal judge rules this week that the government failed to provide on-time pay to federal employees who worked during last year's 16-day shutdown. Remember that one? Joining us in studio with more on this in this week's Legal Loop segment, federal employment attorney Jonathan Bell. Jonathan, good morning. Thanks for joining us.
Good morning. Thanks a lot for having me.
All right, so give us the background on this case. I think most people were concerned about not getting paid because they weren't working, and that's all with the Merit Systems Protection Board. This is about people who did work during the shutdown, correct?
Yeah, these are about the essential workers that were required to work during the government shutdown, and even though they were eventually paid, they were paid late. They weren't paid on time, which is a violation of the FLSA.
And so what is the aftermath of that? Are they just licking their wounds and never getting that, or what could happen now?
I think eventually they will get it. The FLSA breaks the employees down to exempt versus non-exempt. Exempt employees are not going to get anything. They're not entitled to it, according to the ruling.
And who are exempt? What are types of people that are exempt?
The
like
FLSA classifies certain people as exempt, like professionals, lawyers, doctors, higher management, nurses, teachers. I guess what they do is they look at positions that that it comes with the territory, it comes with the job, that they'd be working overtime and they'd only be entitled to the salary. Now the argument is that these exempt workers should be classified as non-exempt because if they don't get their salary on a particular day, they become non-exempt. But the judge didn't buy that and basically dismissed claims relating to the exempt workers.
So the exempt workers, so the ones that are entitled to this compensation, those are people like firefighters and sort of, not a great word, but blue-collar types of people.
Yeah, or federal air marshals, the FAMs. There's going to be these claims are going to be divided into two. Non-exempt workers who worked overtime are going to be entitled to compensation. So if for example, if you worked $500 worth of overtime, and even if you were paid 2-3 weeks later, you have a good chance of collecting another $500 in quote-unquote liquidated damages. So that's one section. The next section are for people who were paid but were paid less than $290. $290 is the minimum wage. So if someone worked, let's say, September 30th, and they were paid for September 30th, but they weren't paid from October 1st to October 5th on time, if that amount was less than $290, they're going to make up the difference. So the way that it essentially breaks down is for people who are on salary for $75,000 and above, who worked on that Monday on October 30th, their pay was over $290 for the week, even for that one day. For people who make $50,000 a year, they made about $200 in the week, and they're going to be entitled to $90. Not big money, but really, you're not bringing this case for the money. You're bringing this case to prove a point that these are federal employees. They worked. They were essential workers, and you can't mess with people's lives by having a government shutdown because of politics.
We're speaking with federal employment attorney Jonathan Bell. What did the government argue in the first place as to why it delayed pay for those people that it should have known are deserving of pay because they were on the job?
They were trying to argue that the FLSA doesn't apply to them with respect to the shutdown, that it would have been illegal for them to pay these employees because Congress didn't appropriate the funds to pay them, and there are criminal penalties. However, in 1970, even though the FLSA became into effect in the 1930s, and I think it was 1974, the FLSA covered the government. So I believe from reading the law, it is in fact strict liability. So they could argue what they want. They do have some defenses as far as arguing some type of good faith. But the good faith argument really goes to the fact that they didn't believe they would be violating the FLSA, and I don't think that's the case here.
And we should point out FLSA stands for Fair Labor Standards Act.
Correct.
And again, it applies to federal employees as well as to everybody else.
Yes, it was originally enacted for private sector employees in the 1930s and the Great Depression era to make sure that people got paid on time or people got paid appropriately for their work.
In fact, I think that goes back to the Bible, actually. You're supposed to pay people on time and not hold the wages of the worker until the morning.
Sure.
And so Now, you said $90, $100, whatever it might be, is not that much for an individual. Indeed, it is not. Do we have any idea of what this is going to cost the whole government?
I haven't seen the numbers yet. I do know that there was approximately 1.3 million essential workers. However, I don't know the comparison now that they got rid of the exempt group. I don't know how much that cut into it. I'm sure it cut into a significant amount. And also, I'm sure there's a lot of federal employees that make more than $75,000. But I'm sure it'll still send the message to Washington, making them think twice about holding federal employee salaries. And to be honest with you, the people who make less than $75,000, those are the individuals that need it more. Those are the individuals that are more likely to be paycheck to paycheck workers. There's not a lot of margin there, and whatever they had to do, call their credit card companies, negotiate, possibly ruin their credit, and maybe made them late on their mortgage. Every dollar counts when you're making that type of money.
Now, there were 2,000 federal workers involved in the complaint that the U.S. Court of Federal Claims recently heard, and the judge there said that, they're entitled to that back pay. What about, and then the law firm representing them has estimated up to 1.3 million employees would be eligible to join the suit, as you mentioned. So that means those 2,000 are representing everybody.
Well, at this point in time, the 2,000 are representing themselves until if the firm gets approved for collective action, which is currently a motion pending, other federal employees have the opportunity to opt in. Now also federal employees don't have to go with that firm. They could go with their own firm. They could start their own cases. But if they want to opt in for the purposes of being with the other 2,000 group, they have the ability to do that. Now, they don't have to wait till the opt-in decision. They could go on the website now and join at any time. So, now, I just want to also be clear that the judge didn't dismiss the case. The judge didn't necessarily say that these people are automatically entitled to these damages yet. So that's still going to be a subject of contention, and they're going to go through discovery, and the judge is ultimately going to make a decision on that later on. The purpose of this is that the defendants or the Department of Justice made a motion to dismiss the case, which was denied in part.
Okay, so what she ruled was that the chief judge here was that the case could go forward, in other words.
Yes, parts of the case could go forward. The only part that can't go forward is for the FLSA people who are exempt.
So if someone's listening to this and they're an hourly worker or they're a lower paid worker that's on salary, what should they do to get in on the suit here? What do they need to do procedurally?
They could go on the law firm's website and there's a Join Us link, and they could sign up there, or they could also call another attorney to see if, in fact, they'll be willing to take on the case in addition to this firm.
Okay, and is your firm kind of hooked into all this also?
We've gotten a lot of calls. We're debating whether or not we want to start something or just refer it out to the attorney who's already handling it. So it's something that we're considering. If we do get some numbers, we might file something on our own.
And so while we have you here, aside from this back pay and so what they're getting is not back pay but damages because of late pay.
Exactly. It's liquidated damages. It's basically exactly what you said. They were already paid, but they weren't paid on time. Okay,
and just give us a sense of what kinds of cases are you seeing besides this one? I mean, what's the general trend in why federal employees are going to lawyers these days? With respect to employment issues?
Well, I've been doing this now for 12 years, and the field has blown up in that short period of time. Anywhere from proposals to removals, people have an opportunity to hire an attorney. The MSPB is huge for me. Disciplinary actions, removals, downgrades, things of that nature. EEO, disability retirement, security clearance. I mean, our firm handles the whole gamut. At any given time, we probably have anywhere between 300 to 500 federal employee clients.
There were two big things that came out from the Merit Systems Protection Board in recent days. One is they're trying to clarify the veterans' hiring preference, which I had no idea what a hairball that really is for agencies. Do you expect that to produce more litigation or maybe more clarity?
I think that it's fortunate. I think that the veterans need more clarity on it, and I think ultimately there will be more litigation. I think it made it, rightfully so, more friendly for the veterans to join and have a viable claim.
And the other thing from the Merit Systems Protection Board was the provision 713 of whatever the part of the U.S. Code was, I think Section 38, that was created by the Veterans Overhaul Law that just passed in light of what was going on at VA which lets senior executives be fired almost at will with a much shortened process. Obviously, it's too early to have any cases come in from that. It does affect a small number of people. But what's your sense of where that might lead legally?
I understand why they'd want to do that, but at the end, I don't think that the original process is broken. I believe that they offer federal employees very good due process rights, and you have to look at things on a case-by-case basis. You have to make sure that they have these due process rights. That's part of being a federal employee in the system. The term expedite makes me a little bit nervous because I feel like that they're not going to have those same considerations that otherwise they'd be entitled to.
All right. Jonathan Bell is the federal employment attorney for the law offices of Jonathan Bell. Thanks so much for joining us.
I really appreciate it. Thank you.